Good. Now, let's go on to cross-examination. And by the way, when you do your direct examination, you noticed all those questions were really simple. Keep it simple. You don't want to lose your witness. You don't want to lose the judge. You don't want to lose the jury. Don't ask anything that's compound. Ask multiple questions. Keep it easy to understand. Now, I'm going to go ahead and skip along because I already said that you have to establish that your witnesses have personal knowledge. Next thing you need to do, anytime you ask a question, anything you ask needs to be relevant. Relevant means that it tends to prove or disprove something that you or the other side needs to prove or disprove to win their case, or goes to the credibility of a witness. As a general rule, if it's relevant, it's going to be admissible, but there are some exceptions about that. And the practice guides really go into a great bit of detail about that. Third thing I'm going to talk about really briefly that is hearsay. You hear that word all the time, but it probably doesn't mean what you think it does. In legalese, hearsay is where you have a witness testify as to a statement made by another person who's not the witness, where you're trying to have that entered into evidence to prove what the facts that the other person said. It's basically a rule that was created for reliability. If somebody said something, you should, or if somebody said something, you should have that witness there to say it. Not somebody else saying what that person had said. Now, with that instead, said, there are going to be a lot of exceptions to this. Business records is one of the common ones. The custodian of records didn't make the business records, but is familiar with the way that they're created, and they're regularly kept in the course of business, so that deals with the issue of authenticity. You're also going to have statements of a party opponent. If the other side says something, that's going to be against their interests, generally you can have another witness attest to it. And the reason that's reliable is because the other side's right there and can testify to try to set the record straight if they didn't. There are also going to be situations where something might sound like hearsay or it's not. Let's say that you have a witness who is testifying as to what somebody said at the scene of, let's say you have a witness who's testifying as to what the victim said at the scene of the accident. It's like, and did you hear when you arrived at the scene of the accident, did you hear Mr. Smith say anything? Yes, he said that the defendant is a horrible person. Objection, hearsay. Your Honor, we're not attempting to enter it to show that the defendant is a horrible person. The reason this is relevant is because it proves that the victim was alive at the time that the witness arrived. You can enter, so even if something is hearsay for one purpose, it might not be hearsay for another. Questioning yourself. Yeah, it's odd. There's no way around that. Most of the time, the court will relax the procedure, especially if you're not in a jury trial, and more or less allow you to tell your story. The other side may oppose this, and the reason is because it's very hard to object if a witness is just allowed to freely tell their story. If there are no questions to object to, you can't issue valid objections. Be prepared to fully question yourself if absolutely possible and hope that the process is relaxed. If you have to question yourself, your process is typically going to be wearing two hats, yourself as attorney, yourself as a witness. You would ask the question, pause, wait for the objection, and then provide the answer. And just repeat this again and again until your questioning is done. The other possibility is if you can work out with the court and the other party to possibly have another person read you questions. However, if you need to rephrase anything, that breaks down very quickly. Hopefully the rules will be a little bit relaxed for you. Now, if you're on the cross-examination side, you get to ask leading questions. Yes?
With regards to objections, do you have to state the reason for the objection, like hearsay or relevance or whatever? Do you have to give a cause?
Technically, yes. Because if you are objecting, you specify the reason for the objection so the judge can rule on it and also preserves it for the record so that the Reviewing body knows what you objected to and why, and can determine whether or not the decision was correct. In some instances, you might just say objection, and before you even have a chance to do anything, the judge is going to jump in. Let's say that it's clearly irrelevant. Were you wearing purple underwear at the time of the act? Objection, and at that point, the judge is probably going to jump to conclusion and say you're objecting on the grounds of relevance, and you're not even going to get there. It depends on the judge, but always be prepared to state the reason. Now, if you're cross-examining, you get to ask leading questions. These are the questions that suggest your answer. Isn't it true at the time of the motor vehicle accident you didn't have a driver's license? And you get to go in and lead these questions along, and you're trying to poke holes in the other side's case, damage their credibility. I had another reading exercise in this, and I'll include the transcripts in the download, and you've got them next, that shows essentially a cross-examination, but I've been signaled that I'm running down to about 2 minutes now, so I'm rushing.
Good afternoon, Ms. Jones. I have just a few questions about your testimony. You just testified that at the time of the motor vehicle accident, you were seated at the outside patio of Gluttony.
Yes, that's correct.
And was it your testimony that you saw the defendant's car, an AMC Gremlin, enter the intersection while the light was red?
Yes, I saw an AMC Gremlin enter into the intersection on a red light.
Your Honor, I'd like to ask that the clerk show the witness what was entered into evidence as Plaintiff's Exhibit A.
Hearing no objections, the clerk will provide the witness with Plaintiff's Exhibit A.
I'd like to direct your attention to what has been marked as Plaintiff's Exhibit A. A few minutes ago, it was your testimony